Thanks very much. To also acknowledge the traditional owners of this land, the Wurundjeri. I finished my law degree in 1995, and during the time that I was at university, was volunteering at Legal Services, helped establish our law society there. Since then, practiced primarily in the field of industrial and employment law, also doing workplace and discrimination law. I was a volunteer legal observer at the World Economic Forum protest down at Crown Casino in 2001, and I've worked as a lawyer and partner at Slater and Gordon, and I wish that there was an organisation like this for all the times that I was at university, and when I was studying I think it would have made an enormous difference, and I congratulate you on organising it. And but I also note that progressive lawyers seem to get up much earlier than they did when I was at university. Whilst it would have been great to have an organisation like this, I think if you called a meeting at 9 o'clock on Saturday, you wouldn't have got this kind of turnout. So I think it's a testament to you all that you're all here, and it really does bode very well. I want to talk today to take a bit of your time and brain space early on a Saturday morning to ask what I think is an important question, which is, should progressives defend the rule of law? And I think it's, if you'll indulge in a bit of conceptual thinking for half an hour on a Saturday morning, I think it's an important question for the reasons that I'll go through. I mean, what is the rule of law? I mean, the rule of law obviously embodies, there's a couple of key elements that are important. One is that it embodies universal principles. The idea is that the law applies to everyone, that the law will be used to adjudicate disputes, and it's the rule of law often counterposed, if you'll pardon the phrasing, to the rule of men. So it's that there are these abstract principles that will apply when resolving disputes, that grant people rights, and it's that determines how you deal with the dispute and what rights you've got, rather than someone, a ruler, used to be a king, just deciding whether or not to give you rights on the basis of, on the basis of your status, on the basis of whim. A second important element of the rule of law is that it's meant to apply equally, and it's meant to apply to the abstract legal person. So there's meant to be an individual who has rights, and it doesn't matter anything about their status, their gender, their race, their class. They should be the bearer of rights equal to everyone else. And I mean, that's probably most clearly embodied in Article 6, United Nations Declaration, that talks about the right to be recognised as a person before the law. So it's empty of content, and you have those rights just by virtue of being a person or being a citizen. From the progressive side, those ideas have historically come under some significant criticism. One of the main criticisms has been that kind of conception of rights and the rule of law privileges formal equality over material equality, and then in fact sometimes formal equality hides material inequality. And that's perhaps most famously summed up by the Anatole France quote that the law in its majesty forbids the rich and poor alike from sleeping under bridges. And the hiding behind that is that it's all well and good to talk about abstractly equal individuals who have the right to be recognised before the law, but what's that doing about actual real inequality? And in fact, in some instances, law and some at one end of the progressive spectrum have said, well, take a look at property, for example. Property law actually just entrenches the existing inequalities and distribution of property. And feminism has made a very important contribution to that debate as well, talking about how, pointing out how the abstractly formal status of people has usually only in reality often applied to men. At the same time as you've had these grandiose principles of the rule of law, the law's also been happy to deny women the vote, has also been happy to say that men are able to rule within a family and to accord husbands, in fact at some stage something akin to ownership rights over wives. And feminism has also made the important point that the attributes of this abstract legal person It's no coincidence that we talk about in law the reasonable man, because in fact it is often the reasonable man, and the characteristics that apply to that so-called abstract person actually, according to some strands of feminism, privilege certain kinds of characteristics, certain kinds of rationality, certain kinds of values over the values that might exist in the private sphere and that have been traditionally associated with women. And a second criticism of the idea of that the rule of law might be progressive, a second criticism that's come from the progressive side, has been to say, well, it's all well and good to talk about formal equality, but it's never actually been the case. Every time that there's been a constitution or a declaration of rights, there's always been people who've been excluded from it. And you have to look no further than the Australian Constitution, that until it was amended, prohibited, had differential treatment for people of Indigenous race. And you have to look at the US Constitution, where it talks about giving slaves, I think it's 3/5 of the right that other citizens have. And there's always, and when you think about terra nullius, it's always been very clear that there have been certain people who don't count as persons before the law. And that arguably every time you set up a legal order, you exclude people at the edges, and there will always be people who don't count. And that's a very second powerful criticism of the rule of law that's been made from the progressive side. Now, I agree with all of that, but I think that there's something going on at a deeper level that actually means we need to perhaps rethink whether or not we should be defending some of the core principles of the rule of law. Because one of the things that those criticisms overlook is that the first half of the 20th century, in a lot of ways, was actually about trying to get the law to redress material inequality. I noticed that the topic of your conference today is about legal revolution. Well, there were some pretty real revolutions going on in the first half of the 20th century, and places like Russia and in Europe. And they were talking about setting up completely new orders. If I can just digress for a moment, I did a PhD thesis at Monash University, and one of the guys that I looked at in that thesis was a Russian jurist in the early 20th century. His name was Pashikanis, and Lenin appointed him to be the first legal commissar in the Russian Revolution, and he thought that law, like the state, had to wither away, and he took his job very seriously. And he, as they were drafting up new legal codes that were going to apply in Russia, his job was to basically sit in an office with a red pen and just sit there saying, too much law, too much law. People would come to him with proposed statutes and he'd say, no, too much. We need less law, not more. And so he was actively involved in trying to make it wither away. So that was going on over in Russia. But elsewhere in democracies, there was the view that, well, we don't want this revolution stuff happening in our backyard. We've got all these people who are getting very agitated about very real material inequalities. What are we going to do? Well, one of the things that they did was say, well, let's look at how we get the law to address material inequality, something that might today be called social justice. So you had this situation where in some of the European constitutions in particular, you actually have these odd phrases, like in the Italian constitution in the 40s, it begins, Italy is a republic founded upon labour. Like, it's a really odd statement. And then in the German Weimar constitution, you have these statements, workers are deserving of special rights, like things that would just be completely just out of the ballpark today. But you had the beginnings of thinking about how do we guarantee substantive legal rights around things like housing, around things like education. In Australia, I know I'm jumping around a bit time-wise, but in Australia, of course, in 1907 we had the Harvester judgment, a very gendered judgment that talked about the minimum wage. But what it said, they said, well, how do you calculate someone's minimum wage? And they said, well, you don't do it on the basis of assessing their productivity or measuring their work. You say, how much does a man, because it was a man, how much does a man need to look after himself and his family and a couple of children and live in frugal comfort? And they set the minimum wage on that basis. And so all of a sudden you had these, and of course things like pensions were set up, and then I think it probably all of this finds its high point in the United Nations declarations when you go further on and look at things like, for example, Article 22. I'm just bringing it up on my iPad, excuse me. That says everyone as a member of society has the right to social security. Article 23, everyone has the right to work. Article 24, everyone has the right to rest and leisure. It's a good one, I like that one. I don't get to enforce it that much myself. But Article 25, everyone has the right to a standard of living adequate for their health and well-being. All of these things, I want to suggest, would have been unthinkable in the prior to the first half of the 20th century. And what they actually reflect is an attempt to try and hold the law to account and hold the law's promises that things have to be, that there's this principle of formal equality. Well, people were holding it to account and saying, well, there's no good having formal equality unless we have material equality as well. And so I think that already by the middle of the 20th century, this idea of an abstract legal person who was who didn't have any material content was already beginning to become the wrong target for progressive legal critique.